Seeing that it's 1 o'clock, I'm going to go ahead and open the hearing on House Bill 1677, an act relative to the administration and settlement of claims of abuse at the Youth Development Center and making an appropriation therefore. This is a combined committee hearing because we found that the jurisdiction belongs in probably 2 of our finance subcommittees, and so Chairman Emmerich is sitting to my left, and he has the right to go ahead and interject anytime he wants. This is going to be a relatively fluid session because I understand this to need to be a working session. We have this is a complicated bill. We want to spend $100 million. It's a lot of money, so we need to be very sure of what we're doing. So we'll probably end up having at least one other working group meeting later. Is there anyone here representing the Attorney General's office? You are? Okay. All right, we'll get to you. Now, for sort of a social note, Representative Rogers is here. She is undergoing some treatment that has made her vulnerable, particularly to the coronavirus. And so if we could maintain social distance from her, Representative Walz, would you have room to move further away, or are you okay the way it is? All right. No, I just want to make sure that Representative Rogers controls her personal space over there. Okay. All right. Very good. With that, what am I forgetting, Representative Weiler, to kick this thing off? Call our first person up from the AG. Yeah. So why don't you come forward? I've gone through this bill in a lot of detail, and I have perhaps 20 or 25 questions. So I'm going to let others ask questions and keep track, and hopefully everything will get asked and answered before we're through. Before we get done, though, or get started, I want to make sure I understand some context, and so I'd like you to correct me or validate what I think is true. What I think is true is that Attorney General Formella has been intending to spend some time with the claimants, an attorney who's representing a number of the claimants, with the idea that they would sit down and try to make sure they understand how this process ought to work, and that their next meeting is on Monday, and that after that Monday meeting, it's entirely possible they may come to some agreements that could cause us to want to amend 1677. That's my understanding. Could you correct or clarify that?
Yes, Representative. And for the record,
we need to know who you are.
Yeah, for the record, I'm Assistant Attorney General Jennifer Ramsey, and General Formella may walk in at any moment. He was planning to be here, but I know he has Governor and Council today as well, so I'll do my best to answer your questions.
Could you spell the last name?
Ramsey. You are correct. We have a meeting scheduled Monday with Plaintiffs' Counsel. We've been promised a proposal from them, and we'll have a few days to review that and then go through it with them. Our goal is to try to resolve, if not all of their concerns, as many of them as we can, so that if we come back to you at another working session, we'll have proposed language to recommend to you that addresses, hopefully, as many of those concerns as we can. We've also reached out to all of the other public commenters at last week's hearing, and we have one agreement with respect to the right to know concern that was raised, and I have some language that I can present to the group if they want to see it today that will address that concern.
So that's good. So you have already some proposed language you'd like to share with the committee?
I do. And
How would you like to do that? Do you have copies to distribute, and do you want to read it or go over the highlights?
I made copies. It is not probably in the proper form that you would like to see an amendment, but I interlineated the language that Ms. Ortolano and I talked about that she indicated would satisfy her concerns. In the analysis section of the bill at Roman 3, after the end of that sentence, we're proposing to insert the words "except for settlement agreements."
I'm sorry, could you tell us again where you're looking?
On the first page in the analysis section at Roman 3, at the end of the sentence, we proposed to insert the words "except for settlement agreements." And then on the third to last page of the document, which is numbered page 5 at the top, down towards the bottom, there is Roman 13. And at the end of that section, we propose to add the language, "with the exception of settlement agreements, which shall remain subject to RSA 91A4, Roman 6." New sentence, "Pursuant to that provision, settlement agreements entered into between claimants and the administrator will remain available for public inspection, except that the personally identifying information of the claimant shall be redacted."
So you're going to offer that in writing so that I don't have to be a very good scribe?
Absolutely. I brought copies, and I think they went to the back. I think you all do
Outstanding.
hole punches, yeah. So then the last speaker was the Coalition Against Sexual and Domestic Violence, and I've also reached out to them. We also have scheduled a meeting with them for next week, following the meeting with Plaintiffs' Counsel. So at the end of the week, anything we're able to agree to with Plaintiffs' Counsel will also be running by the coalition.
So give me a timeline. Assuming that that synergy between these brilliant groups will create new knowledge, when might we expect from that something written that helps us understand what the new knowledge is and how it might affect this bill?
I would think that if not by the end of next week, certainly by the beginning of the following week, we would be able to come back to the committee with some written suggestions for ways to possibly amend the bill. We'll do it on any time frame you need us to do.
Did you just say no later than 1 February?
I think it goes to the beginning of the following week.
Could you give me a date, please? Because I don't do math in my head well.
I'm struggling as well, I'm sorry. Yep. I think Monday the 7th sounds right. It's Friday's the 4th, I believe. Yeah. So Monday the 7th.
And then let me ask the finance chair, if we had a document amending 1677 by the 10th of February, is that too late in the finance committee process? It is not?
I did set up an executive session, I think, for the 11th.
Yeah.
But I can change that because we need to get this bill right.
Right.
And so if it takes some more time, we can take more time.
So Madam Chair, I'd like to invite you to come sit up at the table if you'd like, whatever you want. This is a fairly informal hearing. No, she's already, I meant like up here at the dinner table, but, okay. Very good. So I think that timeline works, and that you've committed the Attorney General to 7 February. Okay, that he's supposed to have all of our statutes annotated, updated.
Personally.
Personally, yeah. So you can sit up at the table there if you want, Mr. Attorney General. What we just agreed to is that we understand that you have a number of critical working groups with a couple of different constituencies, stakeholders, and that to the extent that you come up with new awareness of how this bill should be positioned, you'll have a proposed amendment to 1677 no later than close of business 7 February. Is that a commitment you think you can accept?
Yes, that sounds very workable to me.
Okay,
I apologize for being late. I just got out of Governor and Council.
that's quite all right. Okay, so the part that you missed that's relevant to you is this is a working group, and we're expecting that we're going to have other working group sessions, and so this is going to be more informal than a traditional hearing might be, and that everyone who has questions or concerns, we can enter into a conversation as opposed to sort of the standard hearing Q&A, I think. Because we have members who have co-sponsored this bill. They may have comments to make as well, and I think that's perfectly fine in a working group environment. All right, so I'm going to open it up to the committee, and I had questions that I think may have just been dealt with. And I discussed this with Representative Lynn before the hearing. And my general concern was on page, do you need a moment to get organized?
We're good. I think we're okay. Thank you.
Okay. Was on page 5, lines 28 through 31. That's the section that basically exempted records from the right to know provisions. And is it Rainey or Rains?
Ramsey.
Okay.
Yeah.
Her
Attorney Ramsey.
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 Oh,
yeah.
like the god, Ramsey. Yeah, okay, good. Okay, so Ms. Ramsey gave us a verbal update and passed paper around, and I guess I'm going to ask my questions anyways, and just have you tell me that the language you've provided fixes it, or there's still an issue. Okay. The questions I had was that we had a perception that paragraph 3, or that section, until you corrected it, was probably a violation of Article 8 of the New Hampshire Constitution and conflicted with the 2015 New Hampshire DOJ Guide for Right to Know. And so, so the two questions related to that was right to know says settlements are public info. Why did we want to exempt them? And the other one was that the right to know provides privacy protections. Are those existing protections insufficient? And so I think you must have considered that and come up with some different language. Could you just talk us through what you were doing?
Sure. Yeah, I'll start by addressing the intent behind the language as it was originally. I think we were focusing our thoughts on trying to keep as much confidentiality for victims as possible as they went through the process. So records of what did they say, how did the interview go, what were those exchanges like. We were not, I think that was our focus. We were not ever intending that the dollar amounts and what the ultimate result was would not be public. And I think that's where we can better balance, to your point, Representative, the requirements of the Constitution, Article 1, Part 8, or Part 1, Article 8, sorry, the privacy protections that are already provided for in 91A. I think what we're intending with this language is to balance those two things. So the ultimate outcome of these proceedings would be public, how much money was given, but we would still be able to protect the confidentiality of victims, you know, their names and their what happened leading up to the final outcome.
So I'm just spitballing here. Just take it as a brainstorming effort.
Yeah.
Would there be value, you think, in coming up with an example type of disclosure format that you might use, using obviously fictitious data if you need any data, just so that people early on can see how we're going to know this information, what information you plan to share. Is there any value in that?
I think so. Yeah, showing a very basic example. I do know that I think Attorney Ramsey has had correspondence with New Hampshire Right to Know. So we're working on addressing kind of the specific concerns that have come out of those communities, but I think there would be value in that, and we could certainly do that. It might be a very basic template, but to show an example of what would be disclosed. So to give folks a sense of whether they think that's enough information or whether only seeing that still leaves more that should be shared publicly.
Okay, thank you for that. Would it be reasonable to expect that on the same 7 February timeline?
Yes, I think so.
Okay. Thank you. To the folks at the committee table and the chair in the background, are there any questions that you'd like to review? Would you like answered? Representative Rogers?
Is that one? Does that work? Okay. I have a number of questions. Is this better? Okay, don't mean to yell, but I have a number of questions, and I think some of them you're doing, but I'm just going to kind of throw some of the things I hope that you would, in this document you're going to give us on the 7th, would be addressed in it, and they kind of fall under a few things. The first one that I wanted to bring up is in the statement of purpose. I would like to see something stronger. I know that I don't want us to admit to anything that would in any way jeopardize any of the court action and so forth that's coming forward. But I know my understanding in dealing with victims in the past and dealing with some of the victim groups that are representing them, it's important that to the victims that there be recognition that there was wrong done. And I wondered if there's a way that we can work language into the statement of purpose that that doesn't, while it doesn't admit guilt, admits that there was something, or that the legislature recognized that there was something wrong happening over the last 50 some odd years with children that were put in our charge. We had a responsibility to protect people when they're in our charge and in our care, and that didn't happen. And so I'd like to see if there's a way that language, and I'm willing to work with anybody if I can be of any use with it, but a statement of purpose that addresses that, so that there's some kind of statement there that's recognition of the victims that this wasn't the way we were meant to operate, but do it in such a way that we don't make the state liable or any admissions that would be a problem once it goes to court. Do you think that that's something that we could incorporate into this?
Yes, Representative, I think that's absolutely something we could work on. Because
Okay.
I think we were initially, we're lawyers, so we're going to be cautious on that front, but I think there's definitely some room to work on that.
Okay, because that's one thing that I would, very important to me to have some statement in there. The second thing comes into claim questions, and I think this might be something you're looking to address, is broadening out from just sexual abuse to physical abuse and restraints and so forth when they were used improperly and traumatically to the victims. And I know that your hesitation on the physical abuse was that there are times that there might have been things that were done for the safety or whatever. But that's one of the areas I presume you're going to address with the document you're doing?
Yes, I think we'll definitely be talking about that with the Victims' Counsel. One thing that I should point out is that the way the bill is drafted is it doesn't leave out physical abuse in the event that there's a victim who's also suffered sexual abuse. So
Right.
if someone has suffered sexual abuse, sort of additional physical abuse that they've also suffered would be taken into account.
I understand, but there
Okay.
are some people that had physical abuse, but
Right.
it
okay.
didn't come in to qualify in the statutes for sexual abuse. So-
Yep. Yep. Okay. Yeah. I just wanted to make sure that was clarified. But yes, we are going to talk about that.
Okay.
I do. I think for the reasons I articulated in the last hearing, I do have some concerns, some pretty significant concerns with broadening that definition. But I think for purposes of today, it probably makes sense for us to have those conversations with the Victims Counsel, who appeared at the hearing last week, and have some more discussion on that, I think, before getting into that. Because it may be that we can get to a place that I think would satisfy everyone. And I'd appreciate the opportunity to do some work on that before really, at the end of the day, laying out to you my final kind of strong recommendation on what we do. It's ultimately up to this committee and up to the legislature, of course, but.
I just wanted to enumerate some of the concerns I had and
Yeah.
that I would hope would address. If,
Yep.
Mr. Chairman, is it okay if I just continue, or do you want me to? Okay. The other is a timeline question, and kind of clarifying these, is in the timeline, a few things. First of all, the January 8, 1980 deadline, our date for when claimants, only people that were suffered anything after that. I think a number of us talked about that.
Yep.
And my concern is somebody that was abused or suffered something in 1960 or 1955 is still suffering as much as someone later. So is there a reason that we have to have a date in there, or can we leave it that just anyone that suffered any abuse or anyone that is there, do we have to have that 1980 date on there? Or can we just not have a date at the beginning?
Yep, we certainly don't have to have any date. We originally picked 1980, or we came up with 1980 based on, I think as I said last week, the best estimate, at least I could come up with based on what I've seen through the criminal investigation and where a lot of these allegations have centered. But I think even just from a recommendation standpoint, from my perspective, we should talk about the date and potentially moving it or eliminating it. The bill does provide that it's only the person themselves, or if they're still alive but incapacitated, their representative who can bring a claim. So it's not like estates of decedents can bring claims. So that provides a natural kind of limit to how far back you would look. So anyway, to answer your question, yes, I think from our perspective, from a recommendation perspective, definitely room to look at that, and that's certainly an issue we plan on discussing when we meet with Attorney Vicinanzo.
Because I know that there's some support for having no date and
Yep.
having the limitations in
Yep.
other ways, if we could.
Yep.
Also with the timeline, the question of how long people have the year, and I think I addressed this to you before, just the year. And I understand compacting it, but I think that some of us have myself and some others have concern that that really limits, because a lot of these people have come forward, but a lot of them probably haven't either. And some of them, because of the nature of this, could be in penal institutions, could be in various places, so that the year deadline could be problematic. So I think some of us would like to see that stretched a little bit longer. And I'm not sure the right time, if it's 2 years or 3, but 1 year seems terribly short.
Absolutely, and again, that I think there's plenty of room to have discussion around that. I think it makes sense to have a period where there is a cutoff date at some point, because I think we want to encourage folks who, at the end of the day, will be willing to come forward by a certain date, so the state at some point has knowledge of the full scope of this. How many would potentially participate in this process? But I absolutely see your point that a year might be too short. So I think from my perspective, that really just comes down to what the legislature thinks is the right balance. And we can have that discussion again with Attorney Vicinanzo, who's Victims Counsel, and have that discussion with others.
So Representative Rogers, would you let me interject here?
Sure.
That conversation triggered a couple of thoughts, and I can't keep two things in my head for very long. On the one dealing with the 1 year window to file claims, I noticed that there's language in there that says that the administrator can return a claim if there's insufficient information in the first claim, and it seemed like that could go a couple of times where a claim could get kicked back. It's not really clear to me what happens to that 1 year timeline or deadline. If they haven't actually gotten around to completing a claim in that year because of requested delays by the administrator to get more information, does that extend the clock by the amount that the administrator requests it? I think that would be fair, but it's not in the language as I see it.
Yep, I think, and I'll let Attorney Ramsey correct me if she disagrees. I think the intent would be that the year deadline is by which you'd have to have made your submission. If the administrator then comes back and asks for more information or feels that there was something missing, you've gotten in the window at that point. So we can certainly make that clearer, but I think the intent was that it's not a year to get to the point where the administrator feels like you've submitted all the information you have to submit. It's a year to have filed the claim in the first instance, even if additional information is requested. Is that okay?
Okay, that's great. I'm just an old hospital administrator. I don't know how to read these laws, so I appreciate that. Then the other point about potentially expanding the scope so that the primary issue is beyond sexual abuse but may include physical abuse is the only claim. It just makes me wonder, are these two different statute of limitations issues? I think the legislature passed a law recently saying there is no statute of limitations for sexual abuse, but if we include physical abuse in the scope of what the claim can be, would that suggest a different date instead of 1980 for the physical abuse claims?
So it wouldn't necessarily suggest a different date than 1980, but I think what you're getting at is that there are separate statute of limitations issues with sexual abuse and physical abuse. I think at the end of the day, this bill is essentially intended to waive relevant statutes of limitations because you're going through an alternative process. You're not going to court, so we're not going to be looking as part. If someone files a claim, really what we'd be looking at is to see whether their allegations, at least as it's drafted, were after 1980. We're not going to be looking to see whether there's a separate statute of limitations in the RSAs that may or may not apply. But but I think you're raising a point, which is perhaps worth considering in the discussion of whether to broaden this to physical abuse. Is that the legislature has made certain changes to statute of limitations for sexual abuse that it has not done for physical abuse, and I think that at least reflects a prior policy recognition that sexual abuse is something that we want to take an even more serious look at. Again, not saying physical abuse is a good thing or okay,
right,
but sexual abuse is a different category.
Thank you for that. Representative Rogers, did you have more questions? I'm sorry
Yes.
I interrupted you. I just wanted to get those in.
Thank you. Back to the timeline questions. The other, another one is the whole process is fairly compacted as far as when the hearings and so forth. And I'm a little concerned that it's so compacted. And I think the same reasoning that expanding the time that they can claim and so forth, I think that, and I don't know if this is one of the areas you wanted to address with plaintiff's counsel as well, is maybe broadening that out or loosening it a little bit, because I worry that everybody can meet all those timelines. I mean, in a perfect world, yes.
Yep.
But I think all of us that have practiced in a court or in mediation find that quite often those tight timelines are very constricting. So,
Yep. I think it's a great point. I think the intent of the drafting was to have flexibility in there, if you couldn't meet a timeline. But to your point, we want to make sure that that's there because, as you say, we can aspire to meet very ambitious timelines and then not meet them. Part of the compact timelines is thinking about the victims and trying, especially some who, if they were harmed many, many years ago, to move this process quickly. I think that's something they want to see. But I think to your point, Representative, we wouldn't want to get so ambitious that we put people in a tough spot. So we will take a look at that.
okay. Then I have a question about the next category is the waiver of rights. And there's a few places in there where we talk about the claimant agrees to the determination of the administrator and the arbitrator is final and binding, whether or not any payment is there. And then after submitting a claim, they waive the right to seek any other monetary relief in any form from the state or its employees. And I know I spoke to you about the one of the employees and such, and I understand that most of them aren't going to have a big pocket of funds. But as I said, when I talked about the statement of purpose to victims, quite often it's not the money that's the important, it's the acknowledgement that there was wrongdoing there. So some of them might want to seek, in a particularly egregious, I mean, these all are egregious, but in a few of them, the claimants might want to seek individual action against an employee if it was action like that. And I worry that we're cutting them off from doing that by saying they can't do any action about an employee. I know it says monetary relief, but I just want to make sure that that doesn't constrict them, that they can't go forward and file a claim in civil court if there's something particular. As I said, I think they know they're not going to get a large monetary settlement, but
Yeah.
the acknowledgement that that particular individual did something to them. And I know we are pursuing criminal, but there's also that extra thing.
Yeah, we can absolutely look at that. I think the intent, right, is to sort of say you're waiving additional claims against the state, to say this is
Right.
what the state's going to pay you. But as far as, the employees themselves, we can definitely take a look at that.
Yeah,
And I think to your point, I kind of hit it last week. Some employees we will pursue criminally. There will be others who are there allegations against, and because these cases are so old, it's very tough to build cases that you think you can prove beyond a reasonable doubt. So there will certainly be former employees who allegations have been made against that we will not be able to pursue
okay.
criminally.
I understand. And kind of the last thing, and when I talked about the, back in the timeline and the whole thing is the notice. And if the notice is adequate as far as just, and I think this was brought up in some testimony that day, using newspapers and so forth, as I think I said earlier, because of the nature of this, there's a possibility that some of these folks might be in penal institutions, having graduated, shall we say, from this level. So I think that the notice needs to be stretched out a little bit more and to maybe look at that fact that where would these victims be apt to be? Not all of them are going to be reading the newspapers to know about it, although we all think it's in the news, we should know.
Yep.
Many of them, because of the nature of what they've been through, aren't going to be doing that. So I think that needs to be broadened a little bit from just the public media. And if there's ways to do it, I'm sure you can figure it out. But I'm just worried it's too constricting again.
Yep, we can absolutely take a look at that. Did you have a comment on that?
So
Jen?
I think the notice provision provides that we would also post at DOC.
If that's for the record, could you
Yeah.
speak into the mic?
I'm searching.
This is being recorded, I believe. It's being broadcast. I also think it's being recorded. Mr. Ripple, is the recording of this also going to be online for a while? All right.
I was saying to the Attorney General, I believe that this draft contains language that we would also post it at the Department of Corrections, that the process was going on. If it doesn't, we can certainly add that. And I also heard a comment last time about the possibility that we might want to publish on a broader scale than just within the state of New Hampshire, and that was also something that I had in my notes to contemplate as we work through this next week.
Thank you.
So I assume on the notice, that's fairly well established what constitutes legal notice. And so I would just expect we would follow the standard practice. Are you proposing that we want to take the standard notice practice and expand beyond that?
That would be my suggestion, because where this case is different than what we usually do, and we are talking a number of potential victims and a large amount of money, I think expanding it to suit the nature of the victims here, I think it needs to be expanded a little bit. And I'm not talking about legal notice. I know we can fit those bars, but I'm talking about getting it out so that people can know about it a little further than what we propose.
Yeah.
But I think the Department of Corrections is a good start, and I think just pursuing it from there.
Yeah.
Thoughts, Mr. Attorney General?
Yeah, I think it would make sense to go beyond necessarily what we would typically consider to be adequate legal notice, because that many times is not a very high bar. And so if we're really trying to make a proactive effort to make sure the relevant population knows about this, I think it would make sense. Obviously, there are reasonable limits to that, but I think looking for opportunities through which we can go above and beyond what typically would be adequate legal notice makes sense in this case.
All right. So I want to leverage off of something Representative Rogers and you were talking about earlier. You mentioned that employees, during an investigation, there may be some indication that they've violated a law along the way, and that they might also be subject to criminal referral, if, depending on the facts and circumstances.
Yeah, just to clarify, Representative, I was thinking specifically of the employees who were alleged to have committed the abuse.
No, we're.
Oh, okay.
That's what I mean.
Okay. Yes, that we currently have indicted 11 individuals who
Okay.
are former employees. We expect that there will potentially be more.
So can I share my thought on that?
Sure.
We specifically say that the claims shall be submitted under oath, and the claimants who are believed to have submitted false claims may be referred to. Okay. So should we have sort of mere language that says employees who are suspected of violating laws shall also be referred to appropriate law enforcement? Because it's silent on that, but you just said that we've already indicted or arrested 11. So I'm just, for fairness, just trying to get the balance that we're going to treat ne'er-do-well employees appropriately.
Yeah, and we would. I can explain why that specific provision is in there. We have had one former resident of YDC, or at least one former person who claimed to be a resident of YDC.
Yes, sir. Let me cut you off there, because I think we're going to be agreeing on what you're about to say.
Yep.
Well, I'm actually talking about the flip side. I'm talking about adding a sentence to say that the employee could be subject to penalties. We say claimants can be subjected to employees, but we don't say anything about the employees. So I think Ms. Ramsey understands what I'm saying.
No, I understand what you're saying, and I'm fine with that. I think the point I just wanted to make is that I don't think that anyone would, we don't have to do anything to make an employee or a former victim who gives false statements potentially subject to criminal penalties. I think employees generally know that will be the case, and I think part of the intent here was to make clear that if someone submits a claim, it's under oath, it's false, that they could be referred for prosecution. But I think it would be fine to have that in there, just to your point, so that there's no confusion.
All right. Representative Rogers, are you done?
I'm done. Thank you very much.
All right. If you have anything else, let me know. Are there any other questions by the committee? Representative Leishman?
Thank you, Mr. Chairman. Nice to see you both today, and thanks for taking my question. As far as the appropriation, the $100 million, in reading the legislation, I see that's to also cover your expenses, such as the investigator, the administrator. How much of an impact is this going to have on your agency? And is that $100 million, it sounds like a significant amount of money, which it is, but is there enough money there between the settlement and the administration of this, if you will, mess? I assume that you may need additional outside counsel and so forth.
Yeah, it's a great question, Representative. I think that I don't know. I know that's not the greatest answer. I can't tell you as we sit here today whether it will be enough to cover all of the claims that come in and all of the additional administrative expenses we were to incur as the Department of Justice to administer all of this. I think this represents our best initial estimate as a number that could cover it. We would make every attempt to keep our administrative expenses associated with this as low as possible, so that as much of this money is going to claims as possible. But I I think the best answer I can give to that, there's a possibility it may not be enough. I think we won't have a great sense of that until we won't start to know that for sure until we see all of the claims that come in and we get a real sense of how many folks are participating in this process, because that will affect not only the amount we pay out in claims, it will affect how much it costs to administer it. I can tell you, though, I think we will spend a lot less money from a Department of Justice perspective on this than we would spend on defending all of these cases in court.
Thank you, Mr. Chairman.
So should the legislature be confident that all of the accounting codes will get set up within this fund so that we can clearly differentiate and potentially audit the money spent for the bureaucracy versus, and I say that in a positive, loving way.
Yeah.
The DOJ bureaucracy versus claimants.
Yes, if we were to enact this bill or a version of this bill, you could be 100% confident of that, because I think, while the primary goal of this is to compensate victims and repair some of the damage that's been done, when we're talking about any taxpayer funds, but particularly taxpayer funds of this amount, that type of accounting and making sure there's transparency and the ability to go back and audit to make sure we can keep an eye on how the money's being spent, I think that's critical. So I think you can absolutely be confident of that.
Okay, so Representative Umberger has a question for you. You want to use the mic, ma'am? A mic?
Thank you. I just want to make sure that, are you suggesting that the 100 million will only cover this process? Or will that include people that choose to go to court for settlement?
I think, in my mind, the 100 million is intended to only cover this process, but that's because I think that the goal of this is to have just about everyone come through this process. If only half do and half go to court, what I could see happening is that we don't spend anywhere close to the 100 million on this process, and at that point we may come back to the legislature and recommend that some part of this money because it won't be needed for this settlement process, be used for litigation in court. Does that answer your question?
Thank you.
Okay.
I'm sorry, I don't see your name.
Thank you, Mr. Chair. I hate to belabor this, but last week we heard testimony from an attorney that has 441 individuals that will be part of a suit. And given that number, and given the 100 million, and given the average settlement, this is finance. The math isn't working for me with 100 million. I mean, I certainly appreciate and encourage to be conservative on the front end of something, but given this circumstance, I think we'd be better served if we had and I don't even know if it's possible, as a realistic as possible number to start with. Am I making sense? I'm just concerned that maybe we're a little too low on the bar, or is there a purpose for that? That's all. Thank you. Thank you, Mr. Chair.
Yeah, it's a really good question, Representative, and trust me, we've wrestled with that. There's a couple of pieces of this to keep in mind. One is, again, there's a difficulty in predicting how many will come through the process. I think we have to allow for the possibility that there will be some folks who might come through the process and get very little, if no money, because part of this is designed to be a claims verification process. And when we actually are able to take a look at what some folks might be saying, or take a look at the events some folks might be saying happened, we may find that there's just no information that verifies that. The records don't support it. The records don't support the dates or anywhere close to the dates. And so it's just, until we have a chance to start looking at that, it's difficult. But I think you're raising a point which is a good one, that, we should not assume this 100 million will be it and enough. But because we've set it up in such a way that claims can be paid over time, that there's a claims verification process. We don't know how many will come through. I feel fairly confident in saying 100 million will last quite a long time.
Representative Walls? I don't think you're on.
How about now?
Yes.
Okay. So there's a waiver process in here, and I'm trying to figure out when the waiver happens. So you just suggested that some claimant may come in, and there may not be enough evidence for you to conclude with the evidence you have available that you can prove how that claimant was victimized. But if that claimant has to waive their rights to even get you guys that far, that means that that claimant then, if I'm understanding this correctly, will then not have the opportunity to go out and hire a lawyer on his own and try and prove it independently of what the state is bringing forward on evidence. Am I correct as to when the waiver happens, that they have to sign the waiver only to have you guys say, oh, we can't find enough evidence, and then effectively deny them the real bite at the apple by going to court?
Well, so, yeah, at least as the bill's drafted now, the waiver happens at the beginning of the process. So when they enter the process, but if the process also provides that if there's a disagreement between the administrator, which would be, at least as the bill's drafted now, a designee of the Attorney General, if there's a disagreement between the administrator and the victim, then it can go to arbitration in front of an independent arbitrator. So after all of that, if they go through the process, the administrator doesn't feel there's enough there to justify a claim, and then it goes to arbitration. The arbitrator doesn't feel there's enough there. I guess to answer your question, yes, it's a possible that there may not be much, if any, compensation, and yes, they will have waived their rights to go to court. But I think the reality is that if that were to happen, it means that if they then decided to go to court, the chances of being able to recover anything would be close to non-existent.
Would, for a follow-up, would that victim be represented by counsel at the mediation level? So that,
Yes.
Because depending on when counsel is in there, and the role of counsel would make a huge difference in their ability to prove or to show their claim.
Yep. Yeah, no, the victim would be represented, and I don't, or at least I given that we have 440 who are represented, I would imagine anyone who comes through this process would be represented. So I think the answer to that is yes. I also just want to clarify, I'm not suggesting that I think there will be victims who come through who don't get compensation. I'm really only suggesting that we don't know for sure. We just have to allow for that possibility, and that's one of the possibilities that was baked into other factors that led us to an estimate of $100 million, at least a best estimate of that number for the moment, as we sit here at a very early stage of this.
Will there be discovery available to the claimants?
I think I'm going to answer your question this way. What we're looking to do here is to verify a claim. So it's not going to be an adversarial process. And I think they will have access to any information that we have access to that might lead us to say we don't think this claim should be paid. But they wouldn't have access to discovery in the traditional sense, or the process wouldn't work that way because it's not going to be an adversarial process. So we're going to look at the best information we have. They'll get access to that information. If they ask for something, we will give it to them if we have it. It's not so I think the best way to answer your question is sort of twofold. I wouldn't think of it as discovery because it's going to be more of a claims verification process than an adversarial process. But to the extent there's a discovery analogy in this process, yes, they will get discovery, but it wouldn't work quite the same way as discovery in the traditional litigation sense.
One more question, please?
Is it a follow-up to what you just asked? Because I
No.
want to follow up to what you just asked.
Well, this is going to be real quick, if you don't mind.
Go
And that
ahead.
is there anything in this bill that caps recovery at the 100 million that we're doing? Or say that we end up with 300 million in claims, can we still proceed with 300 million in claims?
Yes, we could still proceed with 300 million in claims. The legislature would need to appropriate additional funds. But yeah, there's nothing in here that's intended to have this be a cap. It just isn't an open-ended appropriation, which I know I think the legislature generally doesn't like, but I think it contemplates potential additional appropriations down the line.
I think it explicitly says the administrator can ask for additional money as
Yeah.
needed, so it's in there.
Right.
So as you were talking about sort of the, modified discovery procedures that you're going to use, I don't recall reading anything about the claimant's ability to make inquiries about state records to help them fulfill their claims. And it sounds like something that you expect and you believe to be rational, and so it makes me wonder if that a sentence or two should be added into an amendment to clarify the claimant's ability to request state records.
So independently of this bill, all of these individuals have the ability to request their own records through the ordinary process that applies to YDC and to DCYF and DHHS. And certainly a cross-reference in this bill to those provisions would certainly, I think, help make that more clear. This also contemplates adopting guidelines by the administrator, and I think in those guidelines would be another place to direct claimants to the places they could go for resources to help document their claims. I think Attorney General Formella has it correct, though, to say that the purpose of this process is to try to verify claims if possible, and that is in the bill at the bottom of page 3. So I'm not sure what discovery they would need, but to the extent that they were to ask the investigator to help them to find something, I think that's contemplated by this and could be made more clear either in the bill or in the guidelines.
Right, and what I'm looking for is not to have every rock turned over, but I am just trying to make sure that we have a bill that is perceived by stakeholders as being fair and balanced. If we start with a nice, fair and balanced law, hopefully that will lead to a trust relationship that's necessary to negotiate all these cases. So that's where I'm coming from.
Absolutely, and I think those are great suggestions.
Okay. So I have more questions. If there's Representative Wallner, you had a question earlier. Do you still have one? Okay. So I have a question of, I'm sorry, where? Oh, yeah, go ahead, Representative Rogers.
I'm sorry, there's one other question that I didn't ask you. In this process, we have the Attorney General as being the administrator, and you're also a party to the actions. I wonder if there's any thought given or any possibility of looking at having a truly neutral, and not to say that your office is not neutral, but it's odd to have a party to what the actions are, be the administrator as well, and essentially the neutral force. And I don't know where else we look, so I'm not suggesting exactly who, but is that something that you thought about, or is there a way to make it truly neutral so it's not a party to the actions?
Yeah, I would think about it this way. It's meant to be a settlement process. It's a unique settlement process, but it's a settlement process. So the Attorney General has been for. I mean, we could go back and look, but I think for most of history, in state history, the authority who can settle cases on behalf of the state. The way this process works, the administrator, takes in the claim and does a review and is the first to maybe makes the first offer on behalf of the state, or is the first line to make an offer to settle on behalf of the state, but then if the, if there's a disagreement, there is a neutral actor here. The arbitrator is the neutral actor. I think the issue with having the administrator be someone other than the Attorney General or the Department of Justice is that then the state doesn't really have a representative in the equation. This is set up so that, the victim and their attorney are in the equation. The administrator is there on behalf of the state to do a review and make an initial offer, and then the arbitrator is the neutral. If the administrator is also neutral, you have the victim who's a party to the case, you have a neutral administrator, so the state really isn't represented by someone who's looking out for the state, and then you have another neutral. So I think it is something we've thought about, because I can understand the initial reaction that, oh geez, well, the administrator is the Attorney General, and the Attorney General's not neutral here. The Attorney General represents the state. But I think as the administrator, either I or my designee would do their best to look at this objectively and come up with something that they think is fair to the state through objective standards. But we would have that neutral arbitrator that's the second layer of protection. And I think that, from my perspective, that's the best and most balanced way to address the concerns and the need for an ultimate neutral decision maker. But certainly, I imagine when we have discussions with Attorney Vicinanzo and others, I imagine we're going to discuss this issue more.
Representative Walz.
Thank you. I'd like just to follow up. I want to return to the waiver because something occurred to me as you're speaking. What we're asking claimants to do is waive their rights before we have any idea how our administrator is going to view their claim. So if we have an administrator who chooses to view the claims as requiring much smaller damages than perhaps the claimants or their attorneys or others would do, certainly after the first few claims are administered, people are going to get the idea and they're not going to sign up and sign the waiver. But even those first few claims, when they come in, when they have no idea how the administrator is going to rule and view their personal damages and the effect on them for their lifetimes, I'm still troubled by having to sign this waiver before you know anything that's going on. And it's so different to me than traditional litigation. And I'm wondering if there's a way around this to not have them completely waive their rights when, you could have an administrator that says, fine, some of these claims that you gave us in that spreadsheet of how you came up with the money were, to me, surprisingly small given the damages that were done to those victims. And the more recent claims, the damages are much larger. If we have a neutral evaluator that's using those kinds of numbers that were in the spreadsheet that you handed out a week ago, those claimants are going to, from my point of view, be undercompensated. And they will have waived their rights, and there's no way around it. So I'm looking for a solution here as to how these claimants don't have to waive their rights before you have some idea of how the neutral evaluator is viewing the damages.
I think one important piece of that gets to your concern, Representative, are the guidelines that would have to be developed. And those guidelines, part of what they would lay out are sort of how to value claims. I talked about this a little bit last week. It's a little bit crass to put it bluntly and honestly, but there's kind of no way really to do this other than to assign a value to different forms of abuse, and that's partly what these guidelines would do. So someone would only be coming into this process once they see what those guidelines look like. As we talked about last week, we would intend to design those in such a way that it would lead to claims that are consistent with consistent with the average that we've found based on our research. But anyone who came into this process would have notice of that. They would see those guidelines. So there would be at least on that front, they would have some notice on how the administrator is going to be looking at these claims. So I think that should address part of your concern. As to when a waiver happens, that I think I can say sitting here today, that's something we're willing to continue to think about. And again, I imagine that we're going to hear some more ideas on perhaps how to have that work. So I think in combination with the fact that this will all have to be based on guidelines, or at least the guidelines will give an indication of how these claims will be valued, and the fact that we can have some more discussion on that point. I mean, that's how I would answer your question sitting here today, because I see the concern. You know, this is I think this is just one component of multiple components of this that are a delicate balance, trying to be fair, but also, you know, account for the obligation to protect the state.
Representative Emmerich?
Thank you. I'm going to talk in more general terms because I'm not an attorney. But since I own my own business, I haven't woken up in the middle of the night so many times since I read this bill. And the caveat that was suggested by some testimony last week about not having a ceiling. Basically, you could bankrupt the state. I mean, this process could bankrupt the state. It would, if over here we're going to do all these claims, and I have nothing, I'm not negative on the claimants, don't get me wrong. They have rights to make the claim. We also have a responsibility to the state to not go bankrupt. So hopefully part of the discussions going forward is to leave it, to have some ceiling. If you want to raise the ceiling, fine. But I think there needs to be a ceiling as part of this bill, at least to have a bill. I don't think I could support something that said, well, whatever happens, happens. So I hope the ceiling stays in there in some form, even though it can be raised. I understand that. The other thing is,
May I ask you a question
Sure.
about that, just to make sure I understand? It currently says there's a $100 million appropriation, and that the administrator must come back to ask for more. Is that inadequate in your view?
no, that's fine. All I'm
right.
saying is I just want to arm you when you go to your next round of discussions that it doesn't disappear. So it's a blank check, so to speak. The other thing is, I think timing-wise, and I think was mentioned earlier, once the gun fires, you're going to get swamped. We already know there's 400 plus claimants, and you've got some things in here that you're going to turn around in 90 days. And I think that was mentioned earlier. I don't think you're going to be able to handle it. I mean, you're getting ready to. By the time this gets signed, you may have 4 months in order to get all these things you're going to do done, until here it comes, and it's going to come in like a tidal wave. Because you know there's 400 and some already standing in line, and when you start advertising, that number could go up. So I don't know how to buffer that for you. I mean, if you had some process that said we'll handle claims as best we can in 90 days, but when the level reaches some number, and I don't know what it is, let's say it's 100 claims, that the process would automatically go to 180 days instead of 90 days, or something. I don't have an answer for you. I just have a problem to give you. So those are my thoughts. I just want to caution that this is going to come in a very big lump.
Yep. No, I agree. You know, I think to your first point, I just want to assure you, I'm absolutely with you on the ceiling concept and the fact that we have to, this is all about balancing the goal of doing, providing some compensation, but also protecting the state, and which is ultimately protecting all of us. You know, we are the state at the end of the day. So I'm with you on that. I don't think you need to worry that that's going to disappear. At least from my perspective, it's ultimately up to you. But from my perspective, that would not disappear from my recommendations. As far as the timelines, we are, not that we would ever assume, you know, what the legislature would or would not enact, but we are preparing for this even now in the event that this gets enacted. So thinking about what guidelines would look like, thinking about how this would work. So we are doing that. I have the same, you know, I'll admit, stress about the timelines. And I think what we're going to continue to try to do is balance the need to make sure this moves quickly, but not, as I said to Representative Rogers, not aspire or not be so ambitious that this just goes off the rails. So I think we've tried to build some buffer in there. In some cases, you know, the timelines, I think it's at best efforts 90 days, but it could be more, but it could be another 90 days. There are other points where it has to be submitted to arbitration within a certain amount of time, but it doesn't necessarily require that arbitration has to then happen within a set time. So we've tried to build some buffer in there, but we will continue to think about that and refine that, because I absolutely recognize that this is going to be a challenge. You know, I would be lying to you if I sat here and said, nope, we will be able to do this easily. This will require a lot of hard work. It will be a challenge, but I am confident that we're up to it, and I'm confident that we will do an honest assessment of what outside help we need, and we'll go get it, and we can keep those costs as low as possible. But we recognize that this will be, if the legislature enacts this bill, that this will be a very challenging process for us to pull off. But I'm confident we can do it, and we will continue to think of ways to make it even more likely that we'll pull it off.
Additional questions? Okay, so I like that train of thought, and because it triggers something I've been wanting to ask you. The effective date on this is September 1, and it seems to me like you all are going to be developing forms, you're negotiating with the stakeholders about this. You want to develop these guidelines probably earlier in the process than later, and then it refers to the need for the administrator to be able to delegate a completed claim to an investigator to go look into the details. So that implies a manpower issue, and perhaps because we're not doing this work now, you need new investigators, additional supplemental folks that you would have to begin the hiring process about now if you're going to have them in September. I'm just guessing. So all of that is a setup to ask the question of, does this effective date need to be sooner, or would you already have the authority to spend money on all of this stuff before this effective date? What, you know, if you feel like you need to start spending some money to get ready to ramp up for this, when would you begin to spend that money? Would you want it to have passed the Senate before you started to ramp up? I'm curious about your timeline.
Yeah, no, it's a good question. You know, to the extent we need to be able to spend money, you know, if we're going to spend it out of this fund, obviously the bill would need to be enacted and be effective before that appropriation takes effect. I think the best way I can answer that is I think it's probably something we need to think about and make sure that we have thought we have this timeline in a form that is workable. We have given that some thought, but I, you know, we have other ways at DOJ to bring in outside resources if we need to through the litigation fund, and I always try to build some flexibility in there. We can reallocate resources internally temporarily if we need to, before we perhaps bring in the additional resources through this fund. So we have ways to address that, but we will, I think for purposes of today, what I should say and commit to is that we'll think about that further. We'll take your concerns into account and see whether we may need to adjust those timelines. Again, we're trying to balance, you know, the need to have time to do what we need to do logistically with the desire to move this.
Right. I mean, you state in here September is when people, or October is when you can start to accept claimant or claims, and that's fine. But it just feels to me like you want the effective date as soon as possible.
Right.
So that you've got the money spigot turned on so you can get ready for October.
Yep.
So if you would think about that.
Yep.
I had another question about the contingency fees. Contingency fees are set up 25% if they just go through the administrative process, and 33 and something percent if they go through arbitration. And I saw where if they go to arbitration, the claimant's attorney is responsible for half of the arbitration costs. And I'm just wondering if that's enough incentive for them to be judicious in their use of the arbitration route. Because I'm a cynical individual, and if somebody can get a significant amount more money and they think the arbitration route is more generous than the administrative route, I don't see from an efficiency perspective anything to keep people from going the more laborious route of arbitration. So do you think these contingency fees are set right? Do you think the penalties, are not penalties, but the disincentives to go to arbitration are set up right so that we don't just have everything end up going to arbitration?
I think so. I mean, I think they're set fine, at least for now. I mean, we can think about it further, but I'll give you my thought process. The way the bill is drafted is that if you go to arbitration, the claimant is responsible for half of the fees. It could come out of their award, but half of any expenses of arbitration. You also could then be responsible for even more attorney's fees because the cap is higher. And I think there's just an inherent risk in arbitration too. I mean, I'm not sure that someone would go into this being that confident that if they don't accept the offer of the administrator, they're going to get more in arbitration. So I think when you add up the additional cost to go and just the risk that you'll get less, I think the incentive probably is well placed, but we can think about that a little more. Just
Look, that's completely a legal culture question that I'm not qualified to answer. I just am looking at it and wondering.
Yep. Yeah, I think to your point, we wouldn't want everyone just going to arbitration because they figure I might as well go to arbitration. But I don't think this is...
I got nothing to lose.
Yeah.
Okay, so 25% for a contingency fee for a system that seems to be fairly simple to set up to get a settlement just sounds to me like maybe it's too rich. We had testimony in the hearing the other day that suggested that claimants were deserving more money. One way to get the claimant more money is to reduce the contingency fees. So how did we get to 25 and 33, and do you still think those are the right numbers?
Yeah, so 20, for one, I'll just say these are caps. So it's not necessarily saying that this would be an automatic 25%. The arbitrator can approve, or the administrator or arbitrator can approve an award of fees up to 25% if you don't go to arbitration, and up to 33% if you go to arbitration. So I think that's the first important point. Those are not to exceed caps. The second point is that I think that we can't assume that someone who comes through this process, that their attorney that they've engaged, was only engaged at the beginning when they came through this process. They still may have done a lot of work before they ever got to this process. And I think that is potentially the case with a lot of the victims that we see represented by counsel who appeared last week. My familiarity with these types of agreements is that 25%, 33%, that doesn't sound high to me. That sounds pretty standard. And you certainly see cases where you have a contingency agreement and you don't do much work at all, but your client gets a large recovery and you do very well.
Yeah.
You see other cases where it doesn't work out as well. That's the nature of contingency. I think that we don't know what the terms are that these particular victims have with their lawyers that they've hired. But in the past, individuals who have brought forward claims against the state for these types of allegations, we've seen fee agreements that have had percentages that look about in this range.
All right.
So I completely agree with you that I'd much rather see more of this money go to the victims themselves, but these numbers don't strike me as being outside of standard numbers.
Okay, thanks. I'm looking at page 4, in the area lines 24 through 28. This is related to the amount of time that's reserved for arbitration. And it says an arbitration meeting can last no longer than 3 hours or can't be scheduled for more than 3 hours. But it gives the arbitrator and the parties can make additional submissions prior to the, wait, that's not what I meant to say. It's, at the arbitration hearing, the parties may present additional evidence and witnesses. And so I'm just wondering if we're maybe potentially hamstringing the arbitrator if we say no more than 3 hours. I mean, what's the point in putting the 3-hour limitation in there?
I think the point, it kind of flows from the intent of this to make this a claims verification process and not a overly adversarial process. And so I think if this process is going to work that way, we wouldn't envision these hearings needing to be longer than 3 hours. I will just look to Attorney Ramsey to see if she has anything to add on that. But I think it flows from that concept, that this is more of a claims verification process than an adversarial arbitration process. Is that right? Do you have anything to add on that? Okay.
Do you see any potential value in adding a sunset clause to this? Or do you think when we wind down the fund, this law will just basically go away? Or should we just sunset it so that it dies on July 1 of 2032?
The law itself?
Yeah.
I guess that, I think it would make sense if the fund is going to go away on July 1.
On June 30th.
Or June 30th, yeah, 2032, I think it makes sense for this statute to just be repealed at that point as well. So, yeah,
Okay.
I think that would make sense.
Okay, because I'll probably forget by 2032 to do that.
Unless you, okay. What?
I think there are some provisions of it that we might want to have
Okay.
remain.
Let's think about that a little bit.
Okay, fine. Because I was thinking you might need 6 months to finish up all the paperwork too. I don't know.
Yep.
Okay, so I think you all attempted to address the right to know issue right out of the gate. And I think the fundamental question still remains, why don't we just say we're going to comply with the right to know law and just keep this a very simple section?
Because I think that would entail parts of this process being open to the public that would not help us if we're trying to encourage a victim to come through this process. I know that there is at the end of the day, even under 91A, if there's a privacy interest that outweighs the public's interest in getting access to information, that can keep something from being made public. But needing to do that analysis for every case and every part of every proceeding, I think would be very burdensome. I think victims would want to have some level of certainty that at least certain parts of this would be kept confidential. And I think, in my mind, the public's interest in this is to know, frankly, how much money is being spent. I think I would feel pretty safe in saying that, a victim's privacy interest in some of the more sensitive details would pretty much always outweigh the public's interest in seeing those details.
So to what extent is there a public interest in the details of the abuse itself? It could potentially get lurid. And so somewhere between lurid and academic, do you imagine describing the nature of the abuse so that people could look at that and go, this monetary expenditure makes sense?
I think that there would be some level of reporting on that. I think what we would not have is the specific instances or details tied to a specific person.
I don't think you could prescribe that in advance, but it just seems to me like that's part of what you're reporting you need to think through is how much is enough and how much is too much.
And I think some of the required reporting to the legislature would address that.
So are there other questions from the committee? Chairman Emmert? Chairman Umberger? Is there anyone in the audience that wants to say something? This is a working session and we're open. Mr. Speaker, you got any words of wisdom for us? All right. Thank you for joining us today.
Thank you.
I think we will try to schedule another Division 3 meeting before the 11th of February. The 11th of February, the full Finance Committee has reserved an opportunity. Go ahead. What are you saying, Chairman? I'm just trying to fall in line with your guidance.
We'll cancel that and move it later, because I don't want you to feel rushed through this.
All right. So can I use your time slot on the 11th of February then? And because presumably the room's been reserved and we can just fall in on that, right? All right. Yes, ma'am.
Thank you. As I recall, Chairman Umberger invited the plaintiffs' counsel to redraft this bill, and I wondered if they had done so and if that was going to be presented today.
Well, it's not going to be presented today because they're not there, but what I heard the AG say, and I don't mean to speak for him, is that they have intentional stakeholder meetings with those folks and that they are working to collaborate on an agreed-upon position that could be reflected in a potential amendment. And I suppose when they bring the potential amendment to us, then the stakeholders will be here, is my hope. Mr. AG, could you want to expand on that?
Yeah, I think that's correct, Representative. The plaintiffs' counsel they have not provided a red line yet. I think in discussing this with them, what we thought would be most productive is that they would start by providing that to us, and we'd sit down and see if we can get to a consensus product. And that would then be presented to you, so it would be sort of a joint red line. It may be that we don't get there or we agree on certain parts, and they may come and present other proposed revisions that we may not recommend. But I think we thought it would be most productive to start with them providing that to us. We can talk about it with them because we haven't seen any specific proposed revisions yet, and see if we can at least get to consensus on as much as possible before we come back before you. That way we can reduce the multiple versions of different sections of this that otherwise might be flying around.
And you're going to do all that by 7 February.
Yep. We're going to have a long meeting on Monday. We'll be having a lot of discussion.
All right. Are there any other questions? Did that answer your question, Representative Walsh? Okay. Representative Hatch? Thank you for the correction. Yes, absolutely. And we've invited Representative Long to also sit in with us to provide some continuity with Representative Rogers should she need it. So, are there any other questions, or if no one in the audience left to speak? It's 2:23. We've gone on just less than an hour and 25 minutes, and with that, I'll close this work session on House Bill 1677.
Thank you.
Thank you. Now so Division 1, I think you're done, but I want to go ahead and recess till 2:30, which is about 6 minutes, so that people can come and go, and we can get ready for a work session on HB 103. So, given that we ended the recess at 2:30 and it's 2:32, we'll go ahead and open a working session on HB 103 FN as amended. We have Representative Joe Shapiro to lead us off. Do you want to give us your introduction for the record?
Yes, for the record, I am Representative Joe Shapiro, representing Cheshire District 16, the city of Keene. And thank you, Mr. Chairman and members of the committee, for allowing me to introduce House Bill 103. As you know, this bill will establish a dental benefit for all adult Medicaid recipients, providing them with preventive and restorative services with the goal of improving the oral health of New Hampshire's neediest citizens. While HB 692, when signed into law by the governor in 2019, created a dental benefit in theory, House Bill 103 is a roadmap to implementation. It takes the work done by the Department of Health and Human Services Working Group and articulates the scope of services and the model of delivery. It also sets clear guideposts going forward with a specific date to put out RFPs for managed care companies, a date to apply for waivers from CMS, and most significantly, a date to actually implement the program, April 1st, 2023. A very similar bill, HB 250, passed the House and Senate in 2020. Unfortunately, it was vetoed. It should be noted, however, that Governor Sununu in his veto message voiced his strong support for an adult Medicaid dental benefit and cited predicted COVID-related shortfalls at that time as his reason for vetoing it. A work group within Health and Human Services Committee, along with Chairman Edwards and staff from DHHS, worked hard this past fall to create a dental benefit that would satisfy those on both sides of the aisle. Compromise led to concessions on both sides. Benefits were pared down and co-payments were added. As currently amended, House Bill 103 will provide diagnostic and preventive services, comprehensive restorative treatments, medical necessary oral surgery, and removable prosthodontics or dentures, only for the most vulnerable populations. Cost sharing will be implemented to the maximum extent allowed under CMS guidelines for those with family incomes of over 100% of the federal poverty level. While a dental benefit will come with a cost, you will see that over 70% will be picked up by the federal government. And I had expected that there would be a revised fiscal note, but I understand that that's not finalized. But I will leave it to the people from Department of Health and Human Services, Mr. Lippman and Dr. Finney, to talk about the financial picture. In addition, we expect that a dental benefit will result in significant cost savings. With improved oral health, people will be more likely to become employed and no longer need Medicaid at all. Expensive emergency department visits will be reduced. Exacerbation of comorbid conditions such as diabetes and heart disease will be reduced, lessening the need for extensive and expensive medical care down the road. A dental benefit for adult Medicaid recipients has been a long time coming. It is a significant step in improving the oral health of our citizens. We have pared down benefits and added cost sharing to encourage patients to take responsibility for their health care, with what some would refer to as having skin in the game. It has been supported by Republicans and Democrats alike. House Bill 103, as amended, was recommended ought to pass by Health and Human Services Committee by a 19-1 vote. It passed the full House by nearly 2-1 margin. We are getting close to making an adult dental benefit a reality that will result in tens of thousands of Granite Staters living with less pain and more dignity. Thank you, and please vote ought to pass when this bill comes to the full Finance Committee.
Do you literally mean ought to pass as amended?
I do literally mean ought to pass as amended.
Okay. Just to set up some context here, the Fiscal Committee often has been viewed to defer completely to the policy committee in terms of the policy, and that our job is primarily, predominantly, to look at the fiscal implications. By agreement, mutual agreement with the chairman, the current chairman of HHS, he has said that he thinks it's fine if we look at the policy issue as, you know, in a rational way, and I've told him that I think HHS ought to be considering fiscal implications when it passes policy. So we don't have a hard firewall. And with that, I want to just touch on a couple of issues in the bill itself. On page 1, line 5. Are you with me? It'll take you a second.
Is this on the amendment or the actual bill?
It says as amended, so I believe this is the current version.
Okay. Where,
Line 5 on page 1. And this is also for Dr. Finney, I believe. And Courtney, what was your last name? I'm sorry. Oh, M-O-R-I-N? Okay, thank you. So you all may have a role in resolving this. It says that restorative treatments for oral health conditions are less expensive than emergency care and prevent oral conditions from developing, blah, blah, blah. So I want to just be really clear. We asked in the working group about the amount of money that we would save on emergency care, and it was really a quite small number. And I just don't want to mislead anyone with this statement. And so I'm just wondering if Representative Shapiro and Ms. Morin and Dr. Finney, if you think that if we deleted the words on line 5 are less expensive than emergency care, and just delete that, so that we're not implying that, are you following me, Representative Shapiro?
Mr. Chairman, I'm not finding where you are.
I'll give you a minute to look at it. So all I'm trying to do is make sure that our purpose statement is precise and fully accurate. And as written, I think it leaves the implication that we're going to be saving money overall in this program by reducing emergency dental care. So I'd like to propose that we delete the words "are less expensive than emergency care" and just have it go treatments for oral health conditions prevent oral conditions from developing into more complex. Do you see what I'm saying? Do you want to think about it, or do you have a response?
I do see what you're saying, and during our earlier discussions in our work group, I think that the amounts of money that would be saved, as you said, did not seem very impressive. However, I think they were also very difficult to determine, and I'm certainly willing to think about this. I don't think it's a big deal, but I do think the general principle that people coming to the emergency room, that care is much more expensive than ongoing preventive care.
Yes, sir, I agree with you. And I think the rest of that sentence carries that burden by saying that prevent oral conditions developing into more complex health conditions that would require medical care. The ER is among the medical care that we'd be preventing. So I'd like to just strip out those words about the emergency room if that's okay with you. And I'll give you time to think about it.
I think at one point there was a thought that we would save so much money that this program wouldn't really cost money because it would
Right,
save so much
right.
money elsewhere, and that's certainly not the case.
Right, right. I think it turned out that the savings on the emergency room were approximately 1/3 of the administrative cost of the program, which would make it kind of insignificant. But all right, so then I'd like to move on to the second item. And maybe this is a Dr. Finney question, but I'll let you guys decide. It's on page 2, line 23 and 24. And I get what this paragraph is doing, and I'm okay with it. Even through smoking cessation counseling, but then it goes, and other services as determined by the commissioner. And so I just want to make sure that we're not opening up a back door to expansion of services without legislative approval.
I would defer to Dr. Finney on that one.
Okay. So you can sit where you are sitting there, Representative, and Dr. Finney and Mr. Lippman, we've got like these intermediate tables if you want to just go sit in one of those and have your own microphone. And Ms. Moran, if you want, you've got room for you too.
I think the first thing that I would like to say about that classification of treatment, diagnostic and preventive services is limited in scope. So when you look at the coding that dental offices need to use to bill for services, there is a very specific and limited scope of services that are included in those two areas. So it's not a place where you could add, say, more removable dentures, or you couldn't add root canal treatment there, because that is not restorative. It's not diagnostic and preventive.
Okay, so you're saying the other services as determined by the commissioner are bound by the purpose of this paragraph to limit it to diagnostic and preventive dental services.
Correct.
You agree with that, Mr. Lippman?
They're the experts on the coding side, but also on the financial side, I think there's two other checkpoints. One is when we go for a budget allocation, and two, when we bring a contract forward in terms of what's specified in amounts with the governor and council. But I defer to the folks across the table who are more familiar with what the coding limitations are.
So I'm happy with that. That's fine. Thank you both. I got one more question, and then I'll okay. The effective date. We're not going to start paying for care until 1 April 23. The effective date on the last page, bottom line, says this act shall take effect upon its passage. I think that's correct, but have you guys thought about this effective date? Is that written the way it really ought to be? Normally it's like 60 days after the governor signs, or.
I think probably the language reflects that in order to do this right and get all the planning and go for the waivers, we need to be able to start to act pretty quickly, because there's a call for an RFI, then we have to do an RFP, then we have to actuarial studies. There's a small window. Assuming this ultimately got passed, we have less than a year to implement it, and there's a lot to be done. It may not seem like a lot, but there is a lot to be done. So, but if I'm not an expert on the point that you're saying in terms of legislative language, I'd look to LBA to see if they have any suggestions there to tighten it up if that's what you're feeling needs to be done. But
yeah, usually Mr. Williams, if he has a problem with something, he'll jump on it. But Mr. Ripple, do you have any thoughts on the way the effective date is laid out there?
I think the effective date is okay for the reasons Henry mentioned. There's a process that's being put in place, so it makes sense that the department would be able to engage in that process immediately. The only thing I would say is Section 3, the appropriation on page 3, as written, that would be available immediately as well, even though it might not be needed immediately. But again, I think Henry might have some commentary on how soon they would need that money.
All right. So.
I guess I guess I don't understand what the advantage would be to waiting 60 days.
It isn't an issue of advantage from my perspective. It's an issue of what works for the department and what works for the people who have to go transcribe this and put it into the RSAs and stuff. And that's why Mr. Williams will oftentimes, he's the legal, you know Mr. Williams, he'll often have a comment on the effective date.
So we can ask him about that.
Yeah, I think I'm okay with it. I just wanted to check because it's a little different. And I forgot to ask Mr. Lippman, Dr. Finney, and Ms. Marin to introduce yourself for the record.
Sure. Henry Lippman, State's Medicaid Director.
I'm Dr. Sarah Finney. I'm the state's Medicaid Dental Director.
Courtney Morin, actuary at Northeast Delta Dental. I'm a fellow of the Society of Actuaries and a member of the American Academy of Actuaries.
And you participated on our work group.
That's correct.
Yeah. Okay. Well, thank you. And Representative Irf, I know you have a few financial questions, so why don't you just run with them?
Actually, I do have a bunch, but that's really what I wanted to get onto. I just wanted to touch on what you were bringing up. Why not just take out the word and other services as determined by the commissioner?
I guess there are times when there might be a new sealant or something that could get introduced clinically. I think if you wanted to tighten it up, I would suggest as defined as those preventative services as professionally in the coding of, I'm not sure what the dental, American Academy of Dental, something to that effect.
I think what I would say, speaking to the code set, every year the American Dental Association reviews all of the dental codes. They have a code committee, a code maintenance committee. Sometimes they delete codes, sometimes they add them, and then sometimes they amend them with the wording. And so that would be a situation, but it would be with any of the codes that, you know, we might have to change something based on the code set changing.
Is that a document or a location in a document that could be referenced
Absolutely, yeah.
instead of just having this generic?
So if I could, if you wanted to, both by the commissioner.
So
and
the
by-
rules of engagement today is we're having a conversation. Colleagues talking to colleagues. So just, if everyone's just polite to each other, then this will work out.
Could I get the spelling of the name for the dentist?
Finnne.
Okay. Thank you.
Sarah with an H?
With an H, yes.
All right.
So are you suggesting that instead of listing the specific services, that there's just a reference to the,
No. So everything's fine up until and other services as determined by the commissioner. Rather than having that clause, if that clause could just reference, this must be a specific document that has these codes specifically related to the diagnostic and preventive dental services. Is that accurate?
Yes.
So that could just identify that clause, so I could actually look at it and read it and say, okay, I get what she's talking about.
Right.
As opposed to, wait, now, look, the way I read this, when I first read it, I was like horrified. Sorry, but I was.
No, I understand your concern, and it's a good question. It's a very logical question, but it's sort of self-containing. I think what I would suggest is that we could say, and other services as determined by annual updates of the CDT code set.
That'd be great.
Okay.
And then you trailed off a little bit. Did you imply that there would be a range of codes that you would specify in the legislation? Or you would just refer to the overall manual of codes?
We refer to the overall code set. It's CDT, which is the codes of diagnostic terminology.
Yeah.
And that is what has to be used both in private and public insurance, in claiming. You know, it's a consistent use of codes for every single dentist.
Yeah, it almost feels like that would inadvertently make it more open to discretion than just leaving it as is, because the overall code book has codes beyond the dental restoration and
If I understood correctly, she's going to reference the ones, the code set related to diagnostic and preventive dental services
within that manual.
Within that,
within that manual.
Okay.
So I'm surprised, because I'm learning something here. Is the code book so specific that there is a code book that only deals with diagnostic and preventive dental services? I would think that that code book has a vast range of oral procedures.
okay, let me give you a quick rundown on the CDT codes. They start with 0, 100 numbers, then 1,000, 2,000, 3,000, 4,000, 5,000, 6,000. Each of those thousands is a different category of service. And so we can be very specific and assign one subset of the code set to each of these areas in the bill.
So let's do that.
Okay.
So,
And if I might, there's another question for Dr.
you can keep going. You're on a roll.
Okay, for Representative Shapiro, I'm sorry. And this actually relates not yet, this is still about your testimony. I thought you referenced 2019 law, chapter law 346225. Is that, did I understand correctly, you actually brought that up? Because I have a question.
Yes.
Okay. You kind of referenced it in the light of, this is expanding upon that. I think we should explicitly amend this bill to repeal that, because I actually went and read that, and it's a whole different approach to this.
I think what that bill did is it actually removed the prohibition of having an adult benefit.
It has date specific when it should be in effect, and that date was a year or more ago. So I just think we should repeal that as part of this somewhere. I'm sure Mr. Ripple could come up with that amendment so that's gone, and this will be the bill or the law that defines the Medicaid dental benefit. Does that make sense?
I think so.
If you really want me to keep going, I will, but that was really fun. Okay. Now I got to refer to my notes.
So while you're doing that, Mr. Ripple, are you catching all these notes so you could put together a draft amendment for the committee?
I have so far. I think the only thing that I'm not quite clear on is the diagnostic and preventive dental services. So that would read, and other services as determined by, I didn't catch the last part.
So Dr. Finney, could you just send a quick email the way you would phrase it and what the number range is that you're referring to Mr. Ripple?
Yes.
Thank you.
And I guess my other question, with respect to eliminating the old April 1st, 2021 requirement that was in the trailer bill from 2019, would you want me to repeal that entire provision or only the April 1st date?
I'd like you to repeal the whole thing.
Okay.
Does that get rid of the work group? Would that?
It would get rid of the previous work group, but I believe the bill before you, House Bill 103, would have the new language for the current work group.
I don't think it mentions a work group. It mentions reporting out
Okay.
to.
So actually, yes, you're correct. That would get rid of the work group.
Is the work group just a subsection of that chapter? Could that one subsection be left and repeal the other bits? Because it actually does, I only read it today. I didn't read it in great detail, but it seemed to describe an actual program.
It did.
I think the program piece would be good to remove, so there's not two sets of programs in law. I think the allowance of a dental benefit and the work group maintaining those things are important, whether they get recodified or remain, as you suggested, as a possibility.
Okay. I'm happy either way, as long as the program is not there.
I just do not want to see the work group be removed, because that's been a huge piece of us getting to this point, and there's been a very wide array of stakeholders from around the state that have been involved in that, and I don't want to see that go away. I think we need that moving forward.
Don't want to kill that.
So I think in that case, the 2019 trailer bill said, it established the working group, then it went on to say the adult dental benefit shall become effective on April 1st, 2021. Each plan shall include, at a minimum, a detailed description of the following, and it went on to say what the proposed plan should include. I could remove everything from each plan shall include until the end of that section. So the work group would remain in place. I would remove everything from the adult dental benefit shall become effective on April 1st, 2021 through the end of that section. And this might be easier if you could see what I'm reading too. So if you'd like, I could print this out and pass it around to everybody.
I can see it, but if the rest want it.
That would be helpful to me.
Okay.
We know what you're doing.
Do you want us to recess for 5 minutes so you can do that? Is that what you're thinking?
Sure.
Okay. So we're going to stand in recess. It's 2:58 now. We'll reconvene at 3:05, 7 minutes.
He comes in every week or so. He lives in big.
But if no one's like bubbling, then the water
I
has been
drank
there.
I drank 2 cups a while ago.
And how you feeling? How's your bowel treatment?
I'm fine, I'm fine.
Prevent oral.
Yeah.
Very good. Let them get their own shoppers, right? Want me to put it in the minutes? No. How many of them ask for not to be thrown out and quit paying rent? And use the government to keep you from. Oh, there's a bunch of them. But there's a lot of them that get, welfare food stamps. Yeah, yeah. It's hard enough to buy their cigarettes, beer, and drugs. Remove all incentives to work hard to get ahead. I don't know why that is. Because that's the kind of people that vote for Democrats. No, with this kind of stuff here. I know you guys are for it. You guys are probably way smarter than me, so I'll go with you. But I'm just telling you. We'll take a look at it in a couple of years. Yeah. 8 kids. No. The first 7 of us all worked hard to buy insurance. Yep. The last one turned into a really bad drunk. He died from acute alcoholism at age 25.
Courtney, do you participate in Auburn's deliberative sessions? Do you go in and vote and stuff? Oh. They're kind of interesting. Yeah, they're sort of run like mini legislatures where, warrants and stuff get debated and people propose amendments, and it's sort of interesting. Never seen anything like it. I've lived in a lot of different places. I've never seen anything like it. It's You know, the town basically forms its own general court.
Don't save enough to buy a house. So they haven't shown.
How long have you lived in Auburn?
That's what they do in many other countries. But we've got to rise up because that is the strength of this country, is we have middle-class people. And that's what
Oh,
all
okay.
the other
March is
nations
8 years for us.
want to
Yeah.
destroy.
Yeah.
Because
March
middle-class
15th,
people make
to be
decisions,
specific.
and they make good decisions or they be suffering. So
Yeah,
they don't
it
want
was
people to make
a
their
very
own
snowy day when I first pulled in, because I didn't know anything about New Hampshire snow, and it snowed like 2 feet. My driveway was just packed, got stuck. It was great. Welcome to New Hampshire, you're stuck in your own driveway. We had been living in a suburb of Rochester, New York, and our daughters had both gotten far enough through the college process that we knew they were never coming back.
Who raised the
No.
kids?
And it was one of those McMansion things where I kind of realized we had to move somewhere when I was walking through the house, and I noticed that there was a room with a piano and a nice couch, and we were calling it the dog room, because only the dogs would go in there, right? And they weren't going to learn how to play the piano, so I thought, you know, part of this is really wasteful. So we just bought a house we bought on Rattlesnake was just meant to be for my wife and I to grow old. Made us, you know,
Lake
reduce.
Winnipesaukee?
Pardon me?
Lake Winnipesaukee rattlesnake or
No. Just we're of the Auburn rattlesnakes.
Auburn?
Yeah.
So do you have a stuffed rattlesnake anywhere in your house?
No, I don't.
You can buy those in Arizona.
I'm pretty sure that the rattlesnake road term came from the windy road.
There were rattlesnakes in New Hampshire.
No.
Yeah.
Too cold, right?
No, they claim that there was a mill along a river
Yeah.
that, you know, and there was a lot of sawdust and stuff, and people claimed that there were rattlesnakes under that mill.
Huh.
You
Rattlesnakes,
know,
right?
they're rare.
Yeah. I would just think that they couldn't handle the New Hampshire winter.
Well, there's other snakes.
Sure.
They go into hibernation in the mud or in the weeds or whatever. Don't breathe much.
Do you have much to say about this bill? You love this bill? Well, Joe's been busting his tail getting people together.
We're getting close, maybe.
Kevin was doing stuff in there.
Yeah, he was just having a hard time finding the right, his printer, he wasn't able to connect to a printer, and then he had to help Janet find it.
Oh, you sent her the message and looking for where,
No, she had opened up HB4.
oh,
Nobody could send to her for whatever reason.
So we're going to stay on recess until Mr. Ripple is ready to come back.
Don't do that.
go to the specific
And
place.
and I say that because we're still being recorded.
Recover a little bit. No,
So that's House Bill for
I wrote 6 pages
2019.
2019.
The break helps.
It's, starts around
No, I think I slipped a few times.
346, 225, I
Grabbed
think,
something as I
224
went
maybe.
down.
Yeah, 224.
46, 225.
346,
Feel something go.
224.
I'd see things like this. Yeah. And I'm wondering what that is.
If you have the bill, it's, usually found the You have an email address, I can send you the link.
My wife is proud. Shake it's 'cause of
I think I got it.
Yeah, hey, this is Jess Edwards for
I think the
the
important
Chester
thing is to
American
maintain that,
Legion 108.
the fact that it's,
And
the prohibition's
we did have
repealed.
to get a
And I
new
think that
car,
may be in a
so,
different
I
section of
just- I
six
have an
twenty.
update.
Well, I just looked at 692, it's in there, and
Yeah.
that was signed.
Right. There is the repeal. I think just want to make sure
Okay.
if they're repealing the old law, that they don't repeal the repeals. You know what I'm saying?
Right. But we're only talking about repealing something from House Bill 4, not from 692.
I think 692 was actually replaced by House Bill 4.
Oh, okay.
Paying attention. Keeps
Yeah, hey, this is
Just
Jess
remember that
Edwards.
House Bill 4 was
calling from the
because
Chester
there wasn't an
American
agreement on
Legion.
the budget, and then that was subsequently how they,
So I
brought
think
it
you left
forward.
me a voicemail saying our auto pay number was declined? Okay, so I got the new and improved number.
No, and then both my wife and I will be handling something like pills and dropping them. This button, why do I have so much trouble buttoning this button?
It does end in 7497. It's 0825.
Thanks, Kevin.
The security code is 347.
I think in 692, it explicitly said it repealed it. I mean, it
Yep.
didn't use the
Hey,
word
thank you so
repeal, but
much.
in this one, it just says that it will create an adult dental benefit. So I think we need to
Okay.
have that.
So-
Yep. Thank you, sir.
I guess this is the part where actually you eliminate the working group comes down here.
Basically, I would suggest we leave. It's two, in the first sentence of three.
So he's saying leave 2 and
First sentence of three.
first sentence and 3.
The first full sentence, which ends right
Ends
there.
with RSA 91A.
Yeah. So keep that.
10, pages 10, lines 10 and 11. All of Roman, oh yeah, Roman 1 comes out too. Okay.
So basically, keep section 2, and keep the first line, first
Three.
sentence of line 3.
Mr. Ripple, you ready to go, I assume?
Yes.
All right, so the working session on HB 103 FN is now back in session. So Mr. Ripple has handed us all a paper. Do you want to talk through this, what you want us to see on here?
Yep, this is just a portion of the trailer bill from 2019, and on the first page, which is page 77, starting on line 7, you can see the provisions that relate to the dental benefit and the working group that initially would have established it, and that goes on to the next page on line 13. So I think the question is which aspects of this you want to repeal in the current bill?
I think the two things that we want to keep in are, number one, that shall develop a plan for the incorporation of an adult dental benefit, establishing an adult dental benefit, and the language about the work group.
So what, to say it differently, what lines, Representative Shapiro, do you see us deleting?
7 through 10. Line 7 through 11. And after page 26.
Are you on?
Okay. So, what Representative Erf is mentioning is lines 7 through 11 to be eliminated, and then go down to line 26. And after 91A, from that sentence down the rest of the page, and the next page, in that same section should be eliminated.
So I got to admit, I'm confused. Seeing what is there now, what are we deleting?
This,
And
this, 4.
Okay, so I'll say what I think we're wanting to do. And then anyone can correct me. We want on page 77 to start deleting from line 7 all the way through line 11. Then we want to drop down to line 26. After where it says RSA 91A, we want to begin deleting the department in consultation with the working group shall, and then that all gets deleted from that point through line 36. Then when we go to page 78, we are deleting lines 1 through 13. Say it louder. 1, 2, okay. So we'll keep the reports. So everything from line 4 down.
Mr. Ripple?
Yep.
Is 346:226 part of this same 2019 chapter law?
It is, yes.
Yeah, so then, yeah, delete that as well, you're right. Delete down to line 13, like you said.
Okay, so
Lines 1 through 13.
1 through 13 get deleted.
I would think that we might want to keep line 7, 8, and 9 up to the word platform on line 9, because that's really language from that bill which is established
Are
as
you on page 77 or 78?
77.
Okay. Okay, so you're
So
proposing we
right at the
keep
beginning.
7 through 11?
Yes, up to the word up till after the word platform,
So on line 9.
right?
So you recommend keeping lines 7, 8, and 9 through the word platform?
Just because that's the language that establishes an adult dental benefit.
So,
But
tell
that's
me what,
repetitious.
It's repetitious in what way, Representative Weiler?
It's in the new bill.
Okay, because we're about to try to pass a new bill, we're saying that this is no longer needed? How do you respond to that, Representative Shapiro? I mean, we are trying to pass a
Yeah,
bill.
Right, I guess this won't go through unless the bill gets passed, so.
Right.
So.
If we don't
right,
pass the bill, then
Right.
this stays, yes.
Right. I'm just worried about losing that, repealing the prohibition about not having an adult benefit. But this will not be included, this will not happen unless the bill goes through and is
Right.
passed. So
And
I
then-
think that would be fine.
Okay. Dr. Finney, do you agree? Do you have, and this can be a little confusing jumping around like this. Are you tracking and are you okay?
Sorry. It was originally meant to be in value-based care, and that is stated in the current legislation.
Yeah, I could have sworn I read value-based care in HB 103.
Right, so we're good. That was the only thing that
You're happy then?
I'm happy then.
Just after it's sort of put together, just like to run it by John Williams to make sure. Like to run it by John Williams after we pull something together in final form.
Yes, sir. So Mr. Ripple, just so we're tracking, would you tell us what you think we just said about page 77 and 78?
Yep, so I think on page 77, we would remove lines 7 through 11. Obviously, that would necessitate renumbering, and also OLS might want to come up with a new section name for what would be the new 225. But effectively, you would remove the substance of lines 7 through 11. And then on page 78,
Would you go down the rest of the page 77?
Because we still
that's
think you're
correct.
at 27.
Yep, so on page 77, we would then eliminate from line 26 through the end of the page, everything that begins with the department in consultation with the working group.
Yes.
Okay, and then what?
And then on page 78, you would delete lines 1 through 13.
Yes.
All right, so I think we're in agreement. on what we think we're going to do, and we stipulate that the department will have an opportunity to run it by Mr. Williams.
Thank you.
So we'll do that before we send it over to OLS. So Kevin, I forget your process when you work on amendments. You work directly with OLS, don't you? So they would end up having to come up with an OLS version of an amendment, like right away. That's how you work. And then we'd get that amendment over to Mr. Lippman for Mr. Williams' review?
Yep, we could do that. We should have one available at some point tomorrow for the department and everybody on the committee to take a look at.
Okay. All right, so going back to the scene of the crime, Representative Irf, do you still have questions?
Yes, thank you, Mr. Chairman. I have my real questions. So I'm glad we have the, oh my goodness. Ms. Moran. What's your function again?
Actuary.
The actuary, thank you. That's really who I wanted to talk to. So I'm assuming you're the one that came up with the cost estimates.
I am not. The cost estimates that you see are from an outside actuarial firm. I did review their preliminary estimates, though. So I can.
Is your microphone on? Because
Yes, it
we're
is.
trying to broadcast to people.
Is that better?
Is it
Would you like me to
usually-
repeat?
Usually you see a red somewhere.
No, not always like ours.
Let's try it this way. Is that
Okay.
better?
I can hear you.
So I did not come up with these estimates that you see. These were done by an outside actuarial firm. I have reviewed their work when they presented to the work group. So I feel I can answer some of the questions about the cost estimates, but really Dr. Finney and Mr. Lippman might be better, but we can all collaborate.
Well, here's my question then. Actually, it's easier than that. Can we get a copy of that? The work that was done by the outside group?
Yes.
Yes.
That's what I'd really like to see that, if that'd be possible.
Normally you like the spreadsheet. I think it's just a simple little thing.
Whatever they have is fine.
I think the confusion is that Department of Health and Human Services uses an outside consultant actuarial called Milliman, is that correct?
Yes,
And-
Milliman.
And they do the actuarial, estimates.
Right, and well, I understand that. I'm assuming it's more complete than just this little spreadsheet that is very similar to the spreadsheet from 2 years ago, except the spreadsheet from 2 years ago had a little bit more detail. So I'm assuming what this actuary did was something that will give me a real idea of how you got to these numbers, because when I look at these numbers, they seem very low. And I'd like to be able to compare them to private plans or whatnot.
I would just say that you'll see a difference definitely between the Medicaid population and a normal plan population, especially given how limited some of these benefits are. So I'll just offer that Northeast Delta Dental did do some pricing on our own just to compare and came up with very similar numbers to what Milliman had come up with. So though you might want to take it and compare it to a regular group insurance rate, you're not going to find similar numbers there.
Okay, so help me understand why it would be a lot lower for the Medicaid population.
The benefits are very limited. In a normal plan, you're going to have crowns covered, for example, and those aren't going to be covered in this benefit offering. And second, there's differences as well. There's pent-up demand for all these people that have not yet had benefits that are going to go in and use the plan. There's also extra transportation costs have been built in. There's differences in benefit maximums. There's just, it's not quite comparing an apple and an orange, but you could look at it that way, that they're still fruit, but they're different.
Okay, so first of all, the transportation was separate, so I get that. But second of all, when you say that they haven't had dental service in a while, that tends to drive up costs, not drive them down. So I'd expect things to even be higher. I would be curious about if Delta Dental is a good comparison. I'd be curious to see your plans as well then, to compare them. Because I know in my case, dental plans cover pretty much cleanings 2 a year, and that's pretty much it. On top of that, you're paying hundreds or more dollars. And certainly crowns aren't included in my plans, in my wife's plan, actually. So I'd just like to see the actual, what you're actually coming up with, because I think the numbers Just looking at them, they seem very low, that's all.
I can certainly share estimates that we've had for this specific population.
Okay, but fine, that'd be great, but then can you compare them to the, can you explain to me, because you just used general population versus this population, but what I heard you say was in the Medicaid population, it was more expensive to get them on track, so to speak. So I'd like to have you, I'd like to understand, right now, but I'd like to understand how you think it's less expensive than a population like us, like me.
I'll try to offer something quickly, and if this doesn't answer it, I can certainly try to provide more. But in a normal employer-paid plan or employer-based plan, the coverage is going to be 100-80-50. So that's going to cover 100% on diagnostic and preventive, those cleanings that you talked about, 80% on restorative, basic restorative, so things like fillings or root canals are sometimes included in that category, oral surgery. And then 50% on services such as crowns or implants or other things. And of course, orthodontia could also be covered supplementally. This
Keep going.
could be, not always, but could be. So, and you said often you have to go in and it might be a couple $100s. Well, a typical crown could cost $1,000 to $1,200. So if it's covered at 50%, yes. Even as an employer-sponsored plan, it could be covered. You still would be paying out of pocket a significant amount. Go ahead.
You're about me? Yeah, you had to pay the whole 100%.
Right, okay,
So
so
are crowns covered in this
in
Medicaid
this
plan?
plan, the crowns are not covered.
Okay,
That's
so
a
that's a
major difference.
match.
But I'm just telling you, most often, plans are gonna cover major services as well. A typical employer-based plan, the most common employer-based group insurance plan does in fact cover major services, and typically those are covered at 50%.
So just if you just send me the plans, that'd probably be the easiest thing for me to look at. Because I know you're a dental person as opposed to a general purpose sort of insurance person. And I think it'd be good to, I don't think most, maybe I'm wrong. I certainly know some corporate plans don't cover like you're describing. Yours covers, which is great. But just let me have the plan so I can compare them, that's all.
I think that the actuarial for the department did estimates based exactly on the way the amendment was written and what services there would be. So I think we should get you whatever information they have, because that's a match to the amended plan. So that, you know, that's what their cost estimates will be based on.
That would be great.
If I could just, oh, go ahead.
So I did want to say two things. I think one is the professional fee schedule that goes along with a commercial plan is higher. We did make an allowance, the actuary did, and the actuary from Milliman was someone who practices in the dental space. It wasn't just a general actuary. They did have general actuary support, but they had someone that specifically deals with dental. So there is a provision to, because Medicaid dentist participation, this plan's only going to work if dentists participate. Right now, there's a very limited network of dentists that will participate. So the cost that you're seeing here also includes an upgrade to the fee schedule for the dentists so that we can get an adequate network.
And then I will just add on to that it's important to understand that Medicaid programs in general across the country do not pay at the same rates as commercial insurance. We're usually at a percentage of commercial, and so that's why these plans do cost less.
I understand that is the goal, but when you say you have to get actual dentists, correct, in New Hampshire that will do the services for a lower part, and in the medical world, that's driven by forcing hospitals to accept lower rates, basically. In the dental world, I don't know that you have that same leverage, do you?
So that's where I think the work group was important in terms of practicing dentists and others in the field, in terms of what was a more normative level of reimbursement that would expect to enlist it. And that's also where a firm like Delta Dental, who has a network, can have a better chance of enrolling dentists because they do business more broadly. You know, the same could be true of another vendor as well, but I'm just saying that that's, I think, that's where the transportation came in as well, because the dentists and the care management that goes with that is the dentist said, you know, I don't mind doing services for Medicaid, but what I do mind is when I have a chair time and no one shows up. And so it's dealing with that no-show rate is part of what is built into the program here, and I think that's what dentists were looking for in the work group.
It wasn't just about reimbursement. There were other support mechanisms that would allow them to consider taking Medicaid.
I do understand that, and you very nicely kept the transportation out, so I understand that that is a separate cost, and I'm not questioning that at all. I was just looking at the dental cost, and I guess I'd be curious to know the, you know, the list of dentists that agreed to these rates, that's all.
I think the other thing that I just wanted to mention, and I'm sorry to go back again to the categories of service, but you will see that it's very difficult to compare two plans unless you really look into the specifics of what categories of service are included in each one, because that accounts for some of the cost difference. One of the things that we tried to achieve with this benefit designed the way that it is was to take care of the disease that was going on in a member's mouth, but not necessarily fix that with fixed crown and bridge work, that you can make a choice between having teeth taken out and then replaced with removable dentures. And so it's this weighing of doing what you need to do to be able to place fillings and also to extract teeth to get patients back to a healthy state, and then replace teeth in those populations that are included to have dentures. And those are all the ways that, as you look at each iteration of the cost estimate, we put something in to see what it did to the cost, we would take something out, but it was all ultimately based on the conversations that occurred at the work group between not only, dentists and hygienists, but other stakeholders and what was really important for the folks that they represented.
When I talked to my dentist about this bill, and he's a dentist who does take Medicaid and also does a lot of work with local private nonprofits. He was quick to tell me all the problems that there would be with this new benefit, including the difficulty of collecting co-payments in his office and having people understand those, and that the Medicaid rates will be too low. At the same time he said all those things, he was absolutely overjoyed that there would be this new dental benefit. That this would just give care to so many people and would decrease unreimbursed care in his office. So I would say that it doesn't fix everything, but it's a great, it's not just a start, it's a great improvement.
I don't question that your plan is a great improvement, not at all. My concern is the cost estimates. That's the part this is sort of what we do here, are these costs, and if you just give me the information so I can look at it, that would be very helpful. There just wasn't enough in the financial note to really get an idea of where the $25 a month, figure came from. That's all I'm asking.
Understood. I think that I have confidence in the work that the actuary did, and I think if we have a chance to share it with you and go over it with you, we can get you to a point where you're comfortable. I think we're comfortable that if that was the budget we had to work with, we could work within it.
Super, thank you.
I do have one statistic that might help significantly, I hope. The standard, the average reimbursement as a percentage of private insurance as calculated by the ADA was 56% in the state of New Hampshire. So on average, in New Hampshire, the Medicaid rate is 56% of what the private insurers are paying. So that right there speaks to what Henry was saying about the price discrepancy in the fees. So that would bring the cost down significantly, because that's all that's being allowed to the dentists.
When you said the Medicaid, you're talking about health care, though, aren't you? Not
No, the dental Medicaid rate, there are, there's a children's program in place now, and it has
You mean the
fees.
MCO that currently does it? That's
Yes.
who you're referring to?
Yep.
No, wait, no, the MCOs do not cover
Yes, one of
the
them does.
pediatric benefit.
One of
That's,
I think in the adult dental area, if somebody's been hurt in a car accident and needs some oral care because of trauma, that Medicaid can pay for that. Isn't that part of
Yes.
current?
yes,
Hold on a second. I'll make sure we're talking about the same thing.
Yeah.
So there are 3 MCOs in New Hampshire that do Medicaid. One of them has a full dental plan.
no.
Yes.
It's not a full dental plan.
One of them has a dental plan.
And that's only for adults.
Yeah, yes.
I just want to make sure that we understand the children's benefit is a comprehensive benefit that is, required by CMS. That is a fee-for-service plan that the state manages. It's not provided by the MCOs.
This plan isn't for children only, is it?
I think we're
This- yeah,
conflating things here.
we're-
I think when you were referring to the 56%, you were referring to the fees that are in the children's program. That's one concept. And so those are the fees that would exist today if we did nothing else in the adult space.
Exactly.
That's sort of point one.
Okay.
Point two, the Merit Health is offering a very limited dental benefit that's much narrower than even what we described here. And I think that the per member per month costs are considerably lower. I think, I'm going to throw out a figure that I'd want to verify, but I think we're talking about $5 kind of range per member per month.
You're talking
maybe even
about the
less.
Merit Health plan has
Yeah.
that lower, which makes sense. It's a
Yeah.
lower,
It's
service, right?
We're not, the state's not paying for it, they're taking that out of their administrative load, and they're doing that because they're a new entrant to the market to try to build up market share. And they have built up a pretty good market share. They're the 3rd largest plan, but they have over 50,000 members now.
so I think that addresses all my questions in that realm.
Representative Weiler? Oh,
I
I'm
can
sorry, I
finish.
thought you were done.
No, I'm just warming up here. This is actually, I think, for you, Mr. Lippman. So we just talked about the Mara Health plan. Do you know what value-added benefits, if any, that are dental-related, the other 2 MCOs offer?
They might be something like an oral kit, like that they might provide on an annual basis. That might be toothbrushes and dental floss and that kind of thing. But there's no provider that they can go to get cleanings or anything like that.
And I guess the last question is, just regarding the appropriation, just out of curiosity, why is that? It's a pretty, and I realize it's not it's not enough to cover the annual appropriation, but it's a fairly significant sum of money for a program that's not even starting in terms of cash until 2024.
So I think there's been, since the original, going back to HB4 and the derivatives of different looks at this benefit, the state's managed care program, we've historically had a lag in what we paid for premiums, and the value of that was sort of just cash. But I think more recently, starting in 21 fiscal year, we've gone to a standpoint of being, if you will, current on premiums, and effectively what we were doing is buying cash flow from, and given the governor's perspective on making payments, since we also have to recognize the cost whether we pay them or not in our comprehensive financial report annually, it just made sense from an economic standpoint to be current in our premiums as opposed to arrears. And so what we propose to do is to have the dental program consistent with how we're running the rest of managed care, which is on a more current basis. And that way, if we started in April of '23, we would need that appropriation available to us to make premium payments.
Thank you.
Representative Weiler?
Yeah, alluding back to something that Mr. Lippman pointed out. Too many Medicaid patients are unreliable at keeping appointments. I'm tempted to say we ought to have a copay. You miss your appointment, you pay us $5.
CMS does not allow us to do that. That's a federal rule.
So we never addressed the unreliability of Medicaid patients. I heard from one person whose practice was he didn't even make appointments. He just looked out in the waiting room. People needed help, came to the waiting room and waited.
I think we do address it in other ways.
That's one of the reasons why we spent a lot of time discussing care coordination and having support from employees of the dental vendor that would work with members to give them support, to find out why is it you're missing your appointments.
They're unreliable people, that's why they're on Medicaid.
There are extenuating circumstances at times. And I think that if we're going to invest in these programs, we need to look at the reasons why people behave in certain ways and try to support them so that they can become healthier.
So to address your question as I understand it, you would propose, and maybe we can do this in future legislation, you would propose some kind of a penalty for a missed appointment so that there's an incentive to not miss appointments. What we have done that I think is a new thing is the department has gone to check to see that we could get a waiver so that we could start to charge some co-pays for the people who come in and actually receive their services. And Dr. Finney is suggesting that we ought to also try to be managing no-shows by providing kind of the wraparound services to help make sure they're able to have the transportation and get there. Now, I think between our best efforts and the inherent unreliability of some of the population, I think we're always going to have some no-shows. I think that's just the cost of doing business, and maybe we can get some stats on that in the future and see if there's a smart way of addressing it.
What I heard her say was that CMS wouldn't allow us to charge for no-shows.
Did you say that?
And my dentist, if I don't show up, would charge me.
Okay, I didn't hear Dr. Finney say that. I apologize. I was listening.
I would agree with you that it is really a big problem, that, having had a private practice, psychotherapy practice for years, and I took Medicaid, it was a real problem for me, and more importantly, for the treatment when people didn't show up. And I think there is, to a certain extent, it's a stereotype, but people who are poorer and people whose lives are more disorganized probably have a higher no-show rate than other people. So I would agree with you that it's a problem, and I think we're trying to address it in a positive way by by supporting people to actually get there. And we also have a reporting aspect to this bill where the department will have to report on various statistics, and I think that would be one of the things that would be important to report about at the end of the year, so we can try to remedy that if it's an obstacle to the whole program working.
One of the major principles in a value-based plan is that the vendor shows that the providers are making improvements year over year. And one of those improvements is to make sure that patients are coming in for the care that they need. But I think what we've realized is it's not always possible for the dental provider to really have any effect on the patient. And so we're looking to have the vendor be a part of that solution, that they're giving support. And it's not just for the dental treatment, because this is going to run over into medical costs in certain situations. So it behooves the vendor to really work with the state and also the providers to improve patient health year after year.
You have a follow-up?
Thank you for the discussion.
Okay, so I have another question and then I have a theory. So let's just do the theory first. I'm actually kind of optimistic that we're not going to run into some big numbers initially on pent-up demand. And part of it's for a good reason, because when Emeritus started their dental program, I think they experienced some adverse selection, and so I think they burnt up some of the pent-up demand by, you know, the adverse selection aspect of them opening the doors. And then the other thing is I keep hearing, and this maybe you could clarify this, we're expecting that initially there's not going to be a fully flushed out network of providers. And if we don't have a fleshed out number of providers, then we have a rate limiting step to how many pent-up demand people can show up just because you know, there's no room at the end. So those are just theories. I don't know if you want to comment on any of that.
If I could comment, I think that it could be true, but we made an allowance if it didn't happen. If the optimistic, if you will, in terms of on a cost standpoint,
Right.
We have provided a factor in here to assume that there would be pent-up demand, but I think it's realistic given what's going on in society in general in terms of medical appointment, dental appointments, that, you know, depending on how long, you know, we're dealing with the COVID situation, that there's a backup and availability, and it would, you know, provide some relief.
So I didn't mean anything actionable by that. I just wanted to convince Representative Shapiro that I think about this other than when he calls me. And maybe this is a question for Mr. Ripple. I'm looking at page, whatever, the first page of the fiscal note, and I'm seeing the 1.7 million in FY22, and I'm a little confused by that. Should that 1.7, instead of being in FY22, find itself in FY23?
We put that there because the act is effective upon passage, so it would be effective this fiscal year.
But as I read it, it's money that sounds like it's going to pay for dental care, because it says 1.39 to fund the benefit for traditional Medicaid population and 337.5 to fund the benefit for the expanded. So that sounds like dental reimbursements, and we're not going to treat our first patient until April 1 of 23.
I agree with that, and the program obviously wouldn't be up and running until 23. We just put it in 22 because since the act is effective upon passage, the department would have the money available to it immediately, even though it wouldn't be spent until the next year.
Okay, I will defer to you because you're the LBA expert. What, Representative?
I mean, if you wanted to, you could actually put that into the bill, but the way it's written, it basically takes effect upon the date. That section that portions it doesn't say a different date. Could have a different effective date if you wanted to.
You know, I like all the dates that's written. I just am just curious why the 1.7 ends up in an earlier fiscal year than what I think the expenditure will actually take place.
So
We can't spend anything practically until we have procured a contract, and that's going to be a while.
It's not going to be before June 30, right? And that's the definition of the end of FY22?
Yeah, I mean, I think we don't even issue an RFI until August of this year, and then go through an RFP and then a contract procurement. I think it's.
So Mr. Ripple, I'll defer to you. As we're amending this, if that's something that should be changed or modified, I'll leave it to you to determine that.
I think it's okay as written, because as a practical matter, the department wouldn't actually spend the money until 23. However, you could solve the problem by, as Representative Irf suggested, just having a different effective date for Section 3 of the bill.
Isn't the effective date fairly quick? As soon as it gets passed, which allows the department to be unleashed to start issuing RFIs and all that stuff. So I kind of like, letting them get going, but you don't put the first patient into the chair until April 1 of 23.
And I think sections 1 and 2 could continue to be effective upon passage. You wouldn't necessarily have to change that. You would only change the effective date for section 3 so that the appropriation wouldn't actually be available to the department until fiscal year 23.
We'd be fine with that if that's technically correct. Right.
Yeah, I just keep thinking of these as public documents, and I'd like them to be accurate so that a layman can pick it up and kind of see what's going on.
So we'd have different effective dates for different parts of the bill.
Yep, I think sections 1 and 2 would be effective upon passage as currently written, and section 3 could be effective July 1st, 2022.
That'd be great. That'd be great. Okay, so Representative Wallner, Representative Rogers, Representative Bean, what do you think? Do you have questions for us? You want to make us smarter somehow? No? We've got a couple lobbyists in the back. You've observed this all afternoon. What do you think? Do you guys want to say anything? You want the opportunity to make a statement? No? All right, so what I think we're going to do is we're going to have Dr. Finney, you're writing up a snippet so that we know what code range is relevant, and you're going to send that to Mr. Ripple. Yes. Mr. Ripple's taken everything else he's heard, and he's going to create an amendment. That amendment will come to, obviously, us, but we need to get it to Mr. Lippman so that Mr. Williams can do his sanity check on it. And so, I'm just trying to think, if we say that we'll meet again on this the 11th of February, which is when we're going to hear 1677 again, it feels to me like we could have a very short meeting if that amendment meets everyone's purposes. Anyone have comments on that timeline?
Will it also be acted upon by the whole Finance Committee on that day?
The Finance Committee was going, I don't want to say all that. The Finance Committee is planning to meet after the 11th of February.
Okay.
So we're releasing it from the subcommittee process to the Finance to have its exec session later.
Okay, so then I had earlier gotten a notice for the 11th for an exec session, but that'll be postponed.
That will be postponed, and in its place, this working group will meet.
Okay.
So Chairman Umberger gave us her time slot for us to meet again. And then she has to go reschedule. Okay? All right. Any last words, Representative Shapiro? This is your baby. How you feeling?
Looks good. I think we're getting there.
Okay.
I just have one more question about the amendment before you wrap up. On page 1, line 5, did you decide to take out the phrase "are less expensive than emergency care"? And I don't recall if a conclusion.
Yes, sir.
Okay.
We're just going to delete that because after the phrase "oral health conditions," starting back up with "prevent oral health" or "prevent oral conditions," everything we need to say is covered by the rest of that anyways.
Okay, thanks.
All right, thank you for asking. Mr. Lippman?
In terms of handling the request of Representative Erf, is that something I could work directly with him on?
That's an excellent question. That's still to-dos. So how do you want to handle that, Mr. Ripple? Do you want Mr. Lippman and to work just directly with Representative Erf until he's satisfied?
Yep, that would be fine. I would just ask if you could copy me on any information that you provide, that'd be great.
Invite you to a call.
Yeah, thanks.
Do it together.
Okay, good catch. Thank you. I would like to thank Representative Rogers for coming and participating in both of these. I can't tell you. It's heroic. Thank you. So that closes the hearing on HB 103.
What time is the meeting on the 11th?
It's going to have to be put into the calendar. Okay. I'm going from memory. I think it's 10 a.m. So just to get it said, while I can say it, I think your participation is heroic. Thank you very much.
district.